Hi everybody, my name is Dr. Kennedy Kelechi Halams. This topic is going to be about business law. Business law consists of the enforceable rules of conduct that govern commercial relationships. For example, a firm is required by law to obey the antitrust laws when it considers merging with another firm. Business activities must follow legal guidelines. Broadly speaking, business law refers to the laws that apply to business entities, such as partnership and corporations. It is sometimes referred to as commercial law because it implies the rights, relations, and conduct of persons and businesses engaged in commerce, merchandising, trade, and sales. It is often considered to be a branch of civil law and deals with issues of both private law and public law. Basically, business law affects business activities, and these business activities must follow legal guidelines. So all contracts, employment decisions, and payments to a supplier are constrained and protected by business law. Each of the six functions affect the different areas of business: management, production and transportation, marketing, research and development, even accounting and finance, and human resources management. Let's look at contracts. Contracts are the basis of many of our daily activities. They provide the means for individuals and businesses to sell and otherwise transfer property, services, and other rights. Without enforceable contracts, commerce will collapse. A contract is a written or spoken agreement, especially one concerning employment, sales, or tenancy that is intended to be enforceable by law. If one party fails to perform as promised, the other party can use the court system to enforce and recover damages or remedy. Parties to a contract. We have the offeror, um, the party who makes an offer to enter into a contract, and we have the offeree, the party to whom an offer to enter into a contract is made. Let's look at the elements of a contract. There's the agreement, and that agreement basically means um, basically involves negotiated and typically legally binding agreements between parties as to a course of action, and there's consideration as an element of contract. Consideration affects the legal value in connection with contracts. It is anything of value promised to another when making a contract. And thirdly, we have the contractual capacity. A contractual capacity involves the ability of an individual to enter into a legally binding contract. A party's contractual capacity may be affected by age, mental capacity, mental illness, intoxication, and other factors defined by law. And then we have lawful objects. Lawful objects sometimes are done with the bonds. Let's look at more of sources of contract law. We have the common law of contracts. We have the Uniform Commercial Code, the reinstatement of the law of contracts, Uniform Computer Information Transactions Act, which is also called. Let's we, um, we have the formation, more of formation, which is part of the contracts. We have bilateral contracts, Um, and bilateral contract is a promise for a promise. It is an agreement formed by an exchange of a promise in which the promise of one party is considered in supporting the promise of another party. Both parties to a bilateral contract make promises. With respect to the promise in issue, the party making the promise is the promisor and the other party is the promisee. The legal detriment incurred by the promisee consists of a different promise by him or her to do something or refrain from doing something that he or she was not previously legally obligated to do or to refrain from doing. And then we have the unilateral contract. It's a promise of an act. Unilateral contracts is a contract in which only one party makes an express promise or undertakes a performance without first securing a reciprocal agreement from the other party. We also have um, part of the unilateral contract. Um, in a unilateral contract or one-sided contract, one party, known as the offeror, makes a promise in exchange for an act by another party, known as the offeree. The offeree acts as the offeror's promise. The offeror is legally obligated to fulfill the contract, but an offeree cannot be forced to act or not act because no return promise has been made to the offeror. After an offeree has performed, only one enforceable promise exists, that of the offeror. We also have the express contract, and this is a contract expressed in oral or written words. Basically, express contract is a contract in which all elements are specifically stated: offer, acceptance, consideration, and the terms are stated as compared to an implied contract in which the existence of the contract is assumed by the circumstances. And then we have the implied in fact contract. It's a contract inferred from the conduct of the parties. It consists of obligations arising from a mutual agreement and intent to promise where the agreement and promise have not been expressed in words. Such contracts are implied from facts and circumstances showing a mutual intent to contract and may Then we have quasi-contracts, which is a contract implied by law to prevent unjust enrichment. We also have the formal contract. A formal contract requires a special form or method of creation. We also have the informal contract, a contract that requires no special form or method. And let's look at enforceability. We have the valid contract, which is a contract that meets all of the essential elements to establish a contract. And we have the void contract. In the void contract, basically no contract exists. Then we have the voidable contract, which is a party that has the option of voiding or enforcing the contract. And then we have the enforceable contract, a contract that cannot be enforced. And then we have the executive contract, which is a contract that is fully performed on both parties, and the executory contract. This is also a contract that is not fully. And then we have an agreement. An agreement is a manifestation by two or more persons of the substance of a contract. It requires an offer and an acceptance. Let's look at an offer. An offer is a manifestation of willingness to enter into a bargain so as to justify another person in understanding that his assent to that bargain is invited and will include it. And this can be found in section 24 of the restatement second of. Termination of an offer. Termination of an offer involves revocation of the offer by the offeror, rejection of the offer by the offeree, counter-offer by the offeree, destruction of the subject matter, death or incompetence of the offerer or offeree, supervening illegality. All these can affect or bring to bear reasons why the contract is terminated. An offeree can prevent the offerer from revoking his or her offer by paying the offerer compensation to keep the offer open for an agreed upon period of time. This payment is called an option contract. The offerer agrees not to sell the property to anyone but the offeree. Acceptance. Acceptance is a manifestation of an assent by the offeree to the terms of the offer in a manner invited or required by the offer as measured by the objective theory of contracts. This can be found in section 50 of the restatement second of contracts. The offeree's acceptance must be unequivocal, basically the mirror image time and mode of acceptance. We have the mailbox rule, which is acceptance upon dispatch rule, and we have the proper dispatch. An acceptance is effective when it is dispatched. And in the proper dispatch, an acceptance must be properly addressed, packaged, and posted to a file within the mailbox rule. Express authorization. A stipulation in the offer that says the acceptance must be by a specified means of communication, e.g., example, by registered mail or telegram. And let's look at this little box of charts. It has an offer and acceptance and then a summary. We have communication by offeror, and then we have effective when, which is when it's effective. An offer is made, and effective when is when it's received by the offeree. And then we also have revocation of offer, and then received by the offeree. Communication by offeree and also effective when. We have when the offer rejection of offer and received by the offeror, counter offer received by offeror, acceptance of offer sent by offeror. Consideration. Consideration is something of legal value given in exchange for a promise. Consideration must be given before a contract can exist. Most common types of consideration are tangible payments, which for example is money or property, performance of an act, for example providing legal services, and then we also have gift and promises. Gift and promises involve gratuitous promises. They are unenforceable because they lack consideration. A completed gift promise becomes a true gift by definition and is irrevocable. Contrast lacking consideration. We have illegal consideration and moral obligations. Illegal consideration involves a contract that cannot be supported by a promise to refrain from doing an illegal act because that is illegal consideration. And also it involves contracts based on illegal consideration and that are void. Let's look at moral obligation. And this involves promises made out of a sense of moral obligation or honor and that are generally not enforceable on the ground that they lack consideration. Contrast lacking consideration continues. We have pre-existing duty and past consideration. Pre-existing duty involves a promise that lacks consideration if a person promises to perform an act or do something he or she is already under an obligation to do. The promise is unenforceable because no new consideration has been given. And then we have past consideration. And past consideration involves prior acts. It will not support a new contract. No consideration must be given. The United Nations Convention on Contracts for the International Sale of Goods. This applies to contracts for the international sale of goods, e.g., the buyer and seller must have their places of business in different countries. Additionally, either both of the nations must be parties to the convention or the contract specifies that the CI. Hi, let's look at Chapter 5, Intellectual Property and Internet Law. Intellectual property rights. Intellectual property rights include patents, copyrights, trademarks, trade secrets, trade names, domain names. These are very valuable business assets protected by federal and state laws from misappropriation. A product, formula, pattern, design, compilation of data, customer list, or other business secrets refers to a trade secret. Many states have adopted the Uniform Trade Secrets Act to give statutory protection to trade secrets. State unfair competition laws allow the owner of a trade secret to bring a lawsuit for misappropriation against anyone who steals a trade secret. To be actionable, the defendant must have obtained the trade secret through unlawful means. The owner of a trade secret is obliged to take all reasonable precautions to prevent those secrets from being discovered by others. If the owner fails to take precautions, the secret is no longer subject to protection under state unfair competition laws. Economic Espionage Act of 1996. The Espionage Act of 1996 makes it a federal crime to steal another's trade secret. It is a federal crime for any person to convert a trade secret to his or her benefit or for the benefit of others, knowing or intending that the act will cause injury to the owner of the trade secret. Federal Patent Statute of 1952. This law is intended to provide an incentive for inventors to invent and to make their inventions public, and to protect patented inventions from infringement. Federal patent law is exclusive. There are no state patents. Let's look at the changes in U.S. patent laws in 1995. The Federal Agreement on Tariffs and Trade caused the following changes in the U.S. patent law. Patents are valid for 20 years instead of the previous term of 17 years. This means within this 20-year interval, nobody can infringe on the patent. The patent term begins to run from the date the patent application is filed instead of when the patent is issued, as was previously the case. Patenting an invention. To be patented, an invention must be novel, useful, non-obvious. Only certain subject matters can be patented. Patentable subject matters include machines, processes, compositions of matter, improvements to existing machines, processes, compositions of matter, designs for an article of manufacture, accessible produce plants, living material invented by a person. Patent infringement, unauthorized use of another's patent. A patent holder may recover damages and other remedies against a patent infringer. Patent holders own exclusive rights to use and exploit their patents. 1 year on sale doctrine. A patent may not be granted if the invention was caused by the public for more than 1 year prior to filing of the patent application. This doctrine forces inventors to file their patent applications at the proper time. The American Inventors Protection Act. Federal statute that permits inventors to file a provincial application with the PTO. This requires the PTO to issue a patent within 3 years in most circumstances. This provides for contested re-examination. Copyright Revision Act of 1976. The Copyright Revision Act of 1976 establishes the requirements for obtaining a copyright. It also protects copyrighted works from infringement. To be protected under federal copyright law, the work must be the original work of the author. Only tangible writings are subject to copyright registration and protection. Registration of copyright. To be protected under federal copyright law, the work must be original work of the author. A copyright is created when an author produces her work. Published and unpublished works may be registered with the U.S. Copyright Office. Registration is permissive and voluntary and can be effected at any time during the term of the copyright. Copyright terms. We have individual copyright holder, life of author plus 70 years, corporate copyright holder, 95 years from the year of first publication, or 120 years from the year of creation, whichever is shorter. Copyright software. Key legislation to afford protection to software and computer chips. Computer Software Copyright Act of 1980, Semiconductor Chip Protection Act of 1984. Copyright infringement occurs when a party copies a substantial and material part of the plaintiff's copyrighted work without permission. A copyright holder may recover damages and other remedies against the infringer. The Fair Use Doctrine. The copyright holder's rights in the work are not absolute. The law permits certain limited unauthorized use of copyrighted materials. Fair Use Doctrine. The following are protected under this doctrine: quotation of the copyrighted work for review or criticism in a scholarly or technical work, used in a parody or satire, Brief quotation in a news report. Reproduction by a teacher or student of a small part of work to illustrate a lesson. Incidental reproduction of a work in a newsreel or broadcast of an event being reported. Reproduction of a work in a legislative or judicial proceeding. No Electronic Theft Act, NET Act of 1997. Digital Millennium Copyright Act of 1998. Landmark law. We have the Lanham Trademark Act of 1946. This establishes the requirements for obtaining a federal mark, protects marks from infringement. Trademarks are registered with the U.S. Patent and Trademark Office, PTO. Trademark law. The original registration of a mark is valid for 10 years. It can be renewed for an unlimited number of 10-year periods. The registrant is entitled to use the registered trademark symbol, which is the R, in connection with a registered trademark. Distinguishness of a mark. To qualify for federal protection, a mark must be distinctive, that is a brand name that is unique and fabricated, or to qualify for federal protection, a mark must have a secondary meaning, that is when an ordinary term has become a brand name. Marks that can be trademarked. Let's look at trademark. A distinctive mark, symbol, name, word, motto, or device that identifies the goods of a particular business, e.g. IBM, Coca-Cola, CNN, MTV. Service mark. Service marks are used to distinguish the services of a holder from those of his competitors. For example, we have United Airlines, Weight Watchers, Marriott Hotels. Marks that can be trademarked. Certification mark. This is used to certify that goods and services are of a certain quality or originate from a particular geographical area. For example, Florida oranges, Napa Valley wines. Collective mark. These are used by cooperatives, associations, and fraternal organizations, e.g. Boy Scouts of America. Marks that can be registered continued. You have the flag or coat of arms of the United States, any state, municipality, or foreign nation. Marks that are immoral or scandalous. Geographical names standing alone, surnames standing alone, any mark that resembles a mark already registered with the federal PTO. The owner of a mark can sue a trade party for the unauthorized use of a mark. The owner must prove that the defendant infringed on the plaintiff mark by using it in an unauthorized manner, and such use is likely to cause confusion, mistake, or deception of the public as to the origin of the goods or service. Generic names. Generic name is a trademark that becomes a common term for a product line or type of service. Once a trademark becomes a generic name, the term loses its protection, and under federal trademark law, because it has become descriptive, the Federal Dilution Act of 1995 protects famous marks from dilution. The Act provides that owners of marks have a valuable property right in their marks that should not be eroded, blurred, tarnished, or diluted in any way by another. The Act is designed to stop those who attempt to benefit from the time and money spent by a company to develop and promote its famous. The Act has three fundamental requirements. The mark must be famous. The use of the other party must be commercial. The use must cause dilution of the distinctive quality of the mark. International protection of intellectual property rights. Paris Convention um, helped in the protection of property rights. Berne Convention, WIPO Copyright Treaty, WIPO Phonogram Treaty.